Welcome to Policy Central Podcast, an initiative by MA Public Policy, Christ deemed to be University, your one-stop destination at all things policy. My name is Sidra Haider, and today we shall be discussing about the new criminal code. With me in the panel, I have Professor Prithvi Raj Singh Chauhan, Professor of Public Policy, Christ University, and an expert in constitutional law. With me, with Professor Prithvi, is Professor Karan Singh Chauhan, who is a professor of Law Department, Christ University, and an expert in criminal jurisprudence. Also, in the panel, we have Prajakta Mukherjee, who is a student of Public Policy, Christ University. Now, I would like to give the mic to Professor Prithvi to lay the foundation of the discussion.
Thank you for introducing us. Friends, on 1st of July this year, the criminal laws came into force, the new criminal laws. Now, these three criminal laws, as we all know, are replacing the colonial laws of IPC, Indian Evidence Act, and the CRPC. Now, the moot point here to discuss is, of course, the colonial legacy that we were carrying for many years. The government wanted to do away with that, and the same process, they replaced the laws with the new the criminal laws. For example, the Indian Penal Code, the IPC, is being replaced by Bharatiya Nyaya Sanhita. Indian Evidence Act is being replaced by Bharatiya Sakshya Adhiniyam, and the CRPC, which is the Criminal Procedural Code for criminal investigation process, is being replaced by Bharatiya Nagarik Suraksha Samhita, BNSS. Now, friend, we must know that for any country for any state, the state to ensure the social justice, you have to have a very robust criminal justice system. And there are a lot of reforms which were pending in the criminal justice system, because we know that if the justice is delayed, there will be no justice. The justice delayed is justice denied, right? We also know the what do you say? If I talk about the prison, the situation in the prison, 75% of them are under trials, right? So there is a huge burden on the criminal process, criminal investigation process. Plus, it is leading to a lot of delays, right? And therefore, the true justice is not being ensured, right? So justice not only has to be done, it also has to be seen to be done, right? So in those lines, the government, thought of, revamping and reforming it. But when you do a deep analysis, you'll find that 75% of the laws are still same. They are verbatim. So what has changed is the remaining 25%. Of course, apart from the title. So there are many the good aspects, as well as the some loopholes which should be reformed in the coming days. As I said, keep on saying that no policy can be perfect, right? Every policy do have some positives and the negative aspects, right? We know that the criminal justice system, you have pendency of cases, millions of cases in the courts. It is already overburdened. So therefore, this government, came up with the three new laws. Of course, as I said, that there are many good aspects to it. But then, I wonder whether the government has done the institutional audit or the institutional preparedness before enacting the laws. Of course, the trainings were being done. But then I still wonder that, because when you talk about the criminal justice system, it is not just the police authorities, but whole judicial system. The judicial officers plus the prison, etc. Right. So everything has to be checked and audited before the laws were being enacted. So a lot of work has to be done on that aspect, because there is no reliable internal institutional preparedness or the audits that was being done. Of course, Professor Karan is an expert in criminal jurisprudence, and he would agree with me that the new laws, the Bharatiya Nyaya Sanhita, has expanded the police powers, because earlier the police custody used to be maybe 15 days, 14 plus 1, but now for most of the offences, they have increased it to 60 to 90 days, which may result into all the custodial tortures. At one hand, we are talking about many rights of the the prisoners, and this, I would say, provision may lead to expansion in the powers of the police authorities, and may also lead to the dilution of the civil liberties. Many definitions to me from my analysis I found are also vague. I mean, the titles of many offenses that they've used were very vague, and whenever there is vagueness, or I would say ambiguity, it may lead to confusion and grave abuse. For example, section 197 of Bharatiya Nyaya Sanhita (BNS) talks about false and misleading information. Now, this is very vague and ambiguous, very open-ended, and it may lead to, it is extraordinarily vague and may lead to a lot of confusion and abuse. Similarly, for sedition, of course, the word Rajdroha is being replaced by Deshdroha, but they have in fact broadened the definition. Though we know that the case of sedition is still sub judice in the apex court, and the colonial law is still sub judice. So now they call all the acts which are endangering the sovereignty, unity, integrity under would fall in the broad category of sedition. So I see this as, of course, some good aspects are really would serve the purpose. For example, these expedited investigation process, because now we are having a technological advantage and artificial intelligence is there. So of course we can, the law says that the compulsory videography and commentary is required at the scene of the incident. Of course it has both the sides to look into it. Of course, a person, should he be catching hold of the offender, or should be doing the videography and maybe also putting the commentary over it? And those police personnel who are already 55 years in age and all, they would find very difficult to learn the technology and may not be able to adapt the change. Plus, and that is a permissible evidence, if I'm not wrong. And yes. Plus, do we have the mobile data? Because see, crimes and offences do not happen just in cities. In the rural places, if something happens, do we have a sufficient storage, right? Does the government or the authorities have come up with some app where you can record the data, right? Because we have limited mobile data, isn't it? And you have to have that technology and the data which has to be given by the authorities. Of course, there are some aspects which may have some objective. I would not say which objective, but then and the one good part which I found was community service. As I said, that 75% of the prisoners are under trial and the judicial system is already overburdened. So community service may lessen the burden over the already overburdened the judicial system for the petty offences. Now, ordinary offences, but without defining what is community service. Now it is still open. Just by saying community service without defining it has further led to a lot of confusion, right? And in fact, in my analysis, when I was going through community service, they are including small theft, defamation cases also is being dealt under. The punishment for that, it would be community service, and attempt to die by suicide with an intention to keep a public official from discharging her duty. Of course, suicide as a provision offense is not being put into the category of crime, but except for the part that you stop the police authorities in protest and you try to self-immolate yourself by putting kerosene oil, etc. Right? So that is still a crime under the broad definition of suicide. Of course, they have come up with the law for mob lynching and the provision for mob lynching under section 103 Bharatiya Nyaya Sanhita. Of course, the objective is well understood. Any kind of lynching by mob on the ground of race, caste and community, which is a crime now. So all kind of hate crimes in mob lynching is now has been put under the category of crime. So I would say that the induction of the technology may result into the speedy trials. Plus, I would also say that the CCTNS, the crime network system, that has also been upgraded. So that may also expedite the cases, and may be a really positive push for the criminal investigation process. Sir, you can take the lead, and because you being the expert in criminal jurisprudence would be well placed to discuss and analyze these things. Sir, over to you.
Okay, thank you, Professor Prithvi. So obviously you have given a wonderful overview of the changes which have been made in the new criminal acts, but I want to go a little bit beyond that, look at the chronology of how these criminal acts were passed. Right. Initially, when the committee was set up for the criminal law reforms in New Delhi, led by Ranveer Singh at that time, New Delhi Vice Chancellor, uh, the objective of that committee was to obviously reform the entire criminal justice process, right? And it is a very good endeavor, actually. I would say it's a positive, welcome step also. But if you look at it a little bit more deeper, you will see that there are some problems in it. First, look at the setup of the committee itself. The committee had 5 members. Out of that 5 members, 3 members were from law domain. They were law professors, like 3 were law vice chancellors of some NLUs. One was a Supreme Court lawyer, and another one was a district court judge. Right. So only 5 people were involved in this. Then obviously, fine. They can have subcommittees. They can have consultation process. Usually, this is how it works. But in this instance, the consultation process only lasted for 3 months, right? And it was not circulated that widely, because if you look at the changes that they have brought in the new criminal acts, they are basically trying to revamp the entire criminal justice system. So probably that would have required more detailed conversation and discussions within from the larger community.
And as you rightly pointed, even that time when the laws were being passed, even the opposition was being, most of the opposition MPs were suspended.
The parliamentary discussion which actually was needed for this type of, because the criminal justice system is one where public is very highly involved in this
and affected
also. So obviously it is a democratic requirement, I would say. It's a constitutional requirement, I would say, that such discussion should have taken place. But at that time, if I believe the news, it was some 150 opposition MPs were suspended from the parliament, and no discussion happened. Although the laws were sent to the standing committee, parliament standing committee, but the recommendations of parliament standing committee were also not followed.
So Professor Karan, I'll interrupt you here. Being a professor of criminal jurisprudence, I mean, what are the different provisions which are which are really good and those which are contentious? So if you can just throw some light over them.
I wouldn't pinpoint them as good or bad. Crime is as what the state defines it to be. So the morality of it is something, it's a separately very entirely different discussion, right? But still, I look at the key changes which are there, which have been made. So one good thing they have done, especially in BNS, is that they have introduced this community service, which is a welcome change, because for small petty offences, of course, imprisonment should be the last resort, right? So in a way it is a good thing, but as you have rightly pointed out, it is only limited to 5 offences, out of which 2 are, one is defamation, one is petty theft, all this sort of thing. So again, it is good, but in a way they should have expanded probably to the other offences which are petty, in the sense probably nuisance in society. Okay, it's not such a huge serious offense.
So Professor, when the police custody has been increased from 50 to 60 or 90 days, what is the objective of this? I mean, of prolonged pre-trial detentions. What is the objective, and I mean, what purpose it will serve?
Objective, obviously, because they are trying to make it more victim-centric. If you see at the or look at the CRPC, the provisions, now you have to inform the victim also. So there is a new responsibility on the part of the investigative officer to do speedy justice and to do this investigation, keep the victim in the loop also. So probably that's why they might have thought that this will help, the extended custody, police custody will help in doing the investigation. But now the problem here is, as you have pointed out earlier, is that they have extended it to till 60 to 90 days. 60 days in less serious offense, 90 days for serious offences. Now the another problem here is, in the provision, if you read carefully, you will see that it can be done in parts also. So it can't be that, okay, for 5 days you are keeping me in the police custody, and now if I'm allowed to go, then I'm allowed to go. No, at any point of time, police can take you into police custody and they can investigate you, they can interrogate you. The problem with this is that it will lead to higher chance of harassment of the accused person.
Torture.
An accused is not a criminal as such, he's not a convicted
unless
person.
he's being convicted.
So easily this provision can be misused to maybe harass a person, right? So although objective probably would be good, I would say, but its implementation,
lessen the burden on the judicial system. and maybe do the thorough investigation before the
Yes.
judicial custody.
That's the
initiates.
objective, to help in the investigation. But the implication of this section on the accused person is very much high, right? It will lead to the violation of his rights indirectly.
100%. So the clear conflict of many fundamental rights.
It is. There are other things also. For example, now they have reintroduced handcuffing also.
Snatching.
Handcuffing. In the CRPC, earlier handcuffing was not required when you're arresting someone, but now they have introduced that as well, especially in serious type of offenses like when you are convicted earlier and second time we are arresting you for some other offense.
Great.
Or it can be about related to this mob lynching or organized crimes. So if you're part of that, then handcuffing is also.
So there are many confusions about the enactment of the laws, especially in fact I had a word with many police officers as well. So if the offence has happened before 1st of July, right, and the investigation is still in the process, it's continuing crime, including the framing of the charges and so on and so forth. So which law would apply? Whether is it IPC or the new BNS?
So when it comes to substantive offence, the new law will not take precedence over the old law for already going on investigation. So in such a case, I would say that it's the old IPC which will apply.
Or both?
No, both will not apply. Only one will apply. So if you look at the when this law was implemented, this was implemented from 1st of July. But anything which happened before that, the old IPC is in force.
No, but sir, the moot question here is that let's say the investigation has been completed or was completed before 1st of July under IPC, and after 1st of July, there are many processes which are there mentioned in the CRPC, like the framing of the charges, trials, etc. So I mean the confusion still persists, don't you think so? Because let's say the investigation has completed, doesn't mean that the whole investigation, I would say the criminal process has come to end. The framing of the charges and declaring etc. may be adjudicated under the new CRPC.
So for procedure, yes, for procedural aspect, the new one will apply, especially when it comes to trial. That is for sure.
But it may lead to confusion.
It will lead to confusion, obviously, because of course capacity building programs have not been done much as it should have been done, and lawyers as well as police officers, even judicial officers, they are very much confused at what to apply, what not to apply, because there are few changes. I wouldn't say very substantive changes, but there are few changes in when it comes to procedure. So obviously it will lead to some vagueness, but Professor Ritu, I think that is expected, because any new system which takes place, it will lead to some uncertainty for some time being. But overall, if the positive impact is there, as you are a professor of policy, you would know that whenever new policy is implemented, there is some pain period in between, right? But afterwards, if this is a good reform, then maybe it might be better. But
change always takes time.
Change always takes time, and change is always
change is the only constant. It's painful.
Yes, for some time. But the thing that we have to look at is whether this change is actually for good, or it will make things work better in a way.
Okay, that's quite interesting. So we can Prajakta. So
yes, I would now like to ask Prajakta to share a few insights on it.
Okay, so I would be talking about the gender perspective. The Bharatiya Nyaya Samhita has tried to make the sections more gender neutral, but I think there are places where it has missed as well. Like for example, under clause 96 in BNS, now any like the word minor child has been added in place of a minor girl. Anyone under the age of 18 has been added. So I think this is a very good initiative taken because it's making it gender neutral. Also, the section 366B of IPC, where importing of any girl or boy, they had basically two different age criteria. For girls it was 21, and for boys it was 18. So now it has, under BNS, it has been made importation of any girl or boy to a foreign country or from a foreign country has been criminalized. So I think this is like BNS is trying to make things more gender
As
neutral.
Professor rightly mentioned, and there is a professor also positive what do you say takeaway from that, especially with regard to child marital rape, because in the IPC, if there is offense where there is sexual intercourse of a minor girl below 18 years, 15 to 18 years in age, either with consent or without consent, was rape. But there was an exception. There was an exception to that, and the exception was that if the girl is your wife, then with consent, I mean the consent doesn't matter. With consent or without consent won't be considered as a rape. So in this sense, this exception to this thing was really discriminatory. But the good thing about the Bharatiya Nyaya Sanhita is that it has identified child marital rape as a crime. It's a rape now. It's a crime, with or without consent.
So, Professor Prithvi, in a way, it's a good thing. What you have rightly pointed out, they have taken the gender perspective very seriously in a way. But again, because I'm a professor, so I obviously talk about the critical aspect of it also. The exception to rape, which was marital rape, is not an offense as such, right? That was already criminalized in 2017 by the Supreme Court judgment. So in a way, it's a welcome step that they have explicitly mentioned in the act. But one more thing, as you have mentioned, right, that any child, right? So any child then means boy or girl. It may mean both, right? So what will happen in those circumstances when the victim is a boy, right, and they are married? Okay, so is it that implication is that the wife will be held liable, because that is unheard of especially in rape offences. We don't look at the female gender as someone who can commit rape, right? But by applying this child definition, right, then what is the implication? What is the intention of the parliament? Because usually rape is not an offense for a woman, right? They cannot commit it according to the IPC or according to the BNS.
They cannot be held.
But here, if it's child, then as far as I know, we don't have same-sex marriage in India. So then what is the implication? Is it the wife who is above the age of 18, if she is having sexual intercourse with a minor boy husband, okay, can she be held liable? Again, it creates this confusion. But overall, I think that requires the intervention of the Supreme Court to give a ruling on this.
Rightly so.
Because this will create some vagueness.
Yeah. In fact, to add over it to you, sir, even if I talk about homosexuality, Section 377, right? Now, of course, that was a crime in IPC. But lately in Navtej Singh Johar versus Union of India 2017, it was being decriminalized. I'm talking about consensual same-sex relation, homosexual relation, same-sex relation, consensual. But for the non-consensual relation, it was still a crime, right? And of course, if there is a non-consensual same-sex relation for girls, right, there were separate rape laws operating. But whenever there is a non-consensual same-sex relation with men, I mean same-sex, right?
Yes.
It was still invoked. Section 377 was still invoked, right? And the person was being booked. I'm talking about the sexual assault on men, right? So same-sex relation. But Bharatiya Nyaya Sanhita has completely done away with Section 377. So now there is any or little recourse left for any sexual assault for men, which is something which is a point of concern.
Yes, it's actually very interesting, because they said we want to be more gender sensitive, and when we look at the definition under Section 2 of the genders, they have included transgenders also under the definition. But when it actually comes to things which matters, like this Section 377, which could be used to protect the victims of sexual assault when it comes to gender which are not
non-consensual,
not women and non-consensual, of course, right? But now, since they have done away with Section 377, there is no recourse for them. So essentially, the law does not govern non-consensual sexual assault on male victims, right? And that's a very huge, I would say, gray area, right? Because there are so many victims now, and nowadays we have seen that it happens. It's not a myth that there are no male sexual victims. Of course there are, right? So there should be something for the protection. And Professor Prithvi, actually, if you look at the history of this acts, in the standing committee they have recommended that this partial version of Section 377 should be retained. Of course, there were some problems with the wordings of the section, the unnatural sexual intercourse and whatnot.
In public also, I think it is a crime.
No.
I mean, in private, I mean, as far as my understanding
No,
goes.
it's not public or private. It's essentially about consensual. If it's public, then you have public nuisance and other obscenity acts will
Okay.
apply. But here, when you look at 377, they said that partially we can apply. We cannot retain the unnatural because that is a colonial language. So maybe we can come up with a more direct language that non-consensual sexual activity between males,
Mhm.
okay, or sexual assault against a male, that may be criminal.
Separate offense.
It's a separate. It can be a separate offense. There was no need to entirely get rid of Section 377. Somehow we could have kept it. So that would be probably a better way to protect the rights of the other gender minorities.
Great.
But that did not happen.
Anything
Professor,
else, Prajakta?
before I was also wondering the provisions for FIR. They say that online FIR thing and all would expedite the judicial system. So can you throw some light over the FIR, some changes which were being made?
Again, it's not such a huge change because the concept of zero FIR or this online FIRs, they were already there, right? So overall, nothing is going to change about it. But the thing about the reality of zero FIR also, I'll tell you, zero FIRs, even though they were in existence earlier, now they are in law, but earlier also by Supreme Court's order, they were being followed. No one files it. In reality, no one files it. If you go to one police station, they will refuse to file. What will you do? The recourse is that you have to go to the SP of that area, right? You will go to the SP. Instead of that, you will go to your locality, your jurisdiction, that police station.
Mm-hmm.
So there's no point to it, right? So I don't think it's a big change. But in relation to FIR, there's another change that they have made. So earlier, FIR filing was mandatory. Now also it is mandatory in a way. But the BNS has introduced one provision which says that police has power to do preliminary inquiry and that inquiry has to last for up to 14 days and it's based on the discretion of the police. So before they start any investigation or they turn a complaint into an FIR, now they have a power to do this inquiry also.
Mm-hmm.
Based on inquiry, if they think that this is not a good enough case to turn into an FIR, okay, then they'll not file an FIR. Now maybe the objective was to empower the police and to get rid of this frivolous complaints, which nowadays we say that someone has posted something and some people are filing a FIR in Gujarat or wherever, here Assam, wherever, right? But it may be misused also for actual victims, especially we look at the interior areas, right? When the justice system or police administration is not that robust, okay, this discretion which is given to police now can be misused, where they will pick and choose. That this complaint is more serious, this complaint is not that serious, and what is the recourse to that? Now you will have to go to the magistrate as the only recourse that you have if a person is not filing an FIR. So in a way, I don't think that is a very positive step overall.
Anything else, Prajakta?
Yes, I would like to throw some light on a few critical aspects that I found in the new criminal laws. So one thing is that in IPC, it was offences affecting the human body. In BNS, it has been changed to offences against women and children. So somewhere, sir, don't you feel that it's making women and children, it's portraying them as a vulnerable section of the society? When we are talking about gender equality of today, so I think it's portraying them in a more vulnerable light. And also, as you were saying that the rape laws for men are very cloudy and they are not mentioned. Also, I would like to say the LGBTQ community, especially the transgenders and the queers who are assaulted and tortured mentally and physically every day. So even they are in a very cloudy area because there is no mention of Section 377 in the new BNS. So I feel somewhere to promote Nari Shakti, they are actually not empowering women. They are actually trying to protect them in such a way that in the society they can be portrayed as some vulnerable section. Also, somewhere there's another thing that I would like to say, that BNS, though it's trying to be gender inclusive, it's missing out the actual essence of gender inclusivity and gender equality. So, sir, do you have any insight on that?
Okay, See, I'll take your second point first, which is the gender inclusivity and looking at the LGBTQ people who are also citizens of India. Apart from doing this, the bare minimum, which is to include transgenders in the definition, I don't think BNS has anything for them. Actually, no, this new criminal act has anything for them or for the protection as such, right? Maybe you can say that mob lynching is one aspect, but again, it's not exactly against or for the protection of LGBT community. It's not made for those people. Regarding the sexual assault on LGBT community people, I think we discussed this point that 377 they have not retained, and we don't know why they have not retained, because it does not make much sense that why are you leaving a big portion
Exactly.
of the population, right, under no protection at all, right? It will have a long lasting effect also, because people can then misuse this opportunity, and anyway this type of offenses are not taken seriously. Now we don't even have an offense, so we can look at the plight of these people. So it is going to be very difficult. The first point that you mentioned, I disagree with this point actually. Why? Because you said Nari Shakti and women empowerment. I think this wordings actually strengthens it. The reason being that when we look at the process of criminalization, there are certain laws which are made specifically for certain class of people, right? And women and children can be considered that certain class of people because they have certain factors, because of society, because society has made them more weaker, society has made them, it's not that they are, it's because of the entire society that they require extra protection as compared to other members of society. That's why rape law is also not a gender neutral law, although people say it should be gender neutral, but rape is actually a social phenomenon. It's not just an act, right? It is dominance of one gender on another gender. So that way the wordings I think reflects that point, that they want to empower and they want to strengthen the rights and protection of the women and children. So that is a welcome step. I don't think it is a huge problem.
So, but no introduction of the word man or male in that would not create a lot of cloudiness or gray area in the law itself. Like if you are implementing something which is coming in the society and will be implemented as a criminal jurisprudence and will be affecting, of course it will be affecting the society and all genders irrespective of who you are, not inclusive of a particular gender in a statement which is going to be implemented in nationwide, don't you think is going to create a lot of confusion or chaos later on? Maybe some problems would be emerging.
Are you talking about rape law?
Yes, sir.
Okay. I mean, obviously people may have different opinions on it, but I believe that rape law should retain that gender specificity. The reason being that, as I've told you, rape is not just a sexual act. Male on male rape happens, this sexual assault happens, and it is heinous, there's no doubt about it. But rape on a woman is a social phenomenon. It happens why? Because of the existence of patriarchy that we have.
Failure of the society.
And it's also more about the see, when it comes to male, it is to satisfy the lust. Probably it happens, right? There's no other underlying issues to it. But when it comes to a woman, this is my reasoning, and people may disagree with it. But when it comes to a woman, it's not just about satisfying that unnatural lust. It is also about putting women in a certain place in the society where they are somewhere down in the hierarchy, right? So in a way, it is about domination.
Okay.
So that's why I don't think that rape should be gender neutral. Obviously, there should be a separate law to protect other types of offenses where sexual assault against males can also be protected.
Sir, I would like to bring one more situation where in BNS they are changing unsound, any criminal offence done by a person of unsound mind will not be criminalized. Like it was in IPC, now from unsound mind they are changing it to mental illness. But according to the MHA definition, 2017 definition, abuse of alcohol and any kind of substance abuse, alcohol, drugs, even if taken voluntarily, is a kind of mental illness. So we see many cases of domestic violence after alcohol or any kind of substance abuse. So if a person under the influence of alcohol is actually uh, uh, hitting or somehow torturing or physically or and mentally his wife, then it won't be criminalized. Isn't it a loophole in BNS?
No, not exactly, because you have to read the entire definition, and of course it has changed the wording. Instead of unsoundness of mind, now it is mental illness, as there, which is there in the MHA. But then the second part of the definition says that because of this mental illness, he does not know the nature of the act. So it is a test actually, right? If he does not know the nature of the act, or he does not know what he is doing is bad, right? So in a way, it talks about incapacity. Because of this mental illness, he is incapable to decide or know what he is doing. Then only he can be given this insanity defense. Otherwise, even in the new act also, I think no other change is there in terms of the loophole. So if voluntarily you are taking anyway, you can't take this defense, right? Especially alcohol or whatever. So only some part of mental health that definition is there, but you have to look at the separate test also for this, which is the incapacity. But since you have spoken about it, the definition which is there in MHA is quite limited actually, because when it comes to unsoundness of mind earlier, that was more wider, I would say. Because it included those things also which are not categorized as mental illness, as long as you are incapable to know the nature of that. But now, since they have said that it is only mental illness, so for example, probably sleepwalking or probably sudden actions, I don't know, could be anything, right, which are not part of mental illness. Now, for those offenses where the person is under unsoundness of mind, if he tries to take this defense, he will not be able to, or there is at least a vague understanding now, and it was not even required, to be honest. The unsoundness of mind is much better, I would say, instead of this new definition, because now it is narrower, which means that in a way they have taken rights, not rights I would say, but instances where we could have used this as a defense from the accused person.
Sir, as like with the discussion, it can come to this analysis that any change in the society that is brought about is for the protection of constitutional rights, human rights, and for the self-defense of the Indian citizens. But since there are so many loopholes, be it LGBTQ community or the inclusion of male rape or any mention of child or any other kind of mention, not mentioning any particular gender in any kind of a section, is it not going to bring about a lot of confusion as well as many loopholes in while implementation, which will create a lot of problems while being implemented and on the part of the judiciary as well as the executive? So is it not that the legislature should once or again go through the entire thing, and whatever there are debates going on, they should take into consideration? Because of course everything which happens in the country should be happening for the betterment of the people and for the welfare of the state. If there are so many loopholes, I think it will not be able to sustain well. So what are your thoughts about it?
Absolutely, I agree with you that the government has to go back into the drawing rooms and again look at it, that how we can improve. Obviously they cannot get rid of the laws. Now they are
Inaction.
they are a reality now. We can't just keep ourselves blind to it, but probably through amendments. And I think I was reading a news report recently that government is planning to bring some sort of provision to cover 377 those offences. But when will it happen? We don't know. Another thing you have spoken about is the constitutional aspect of it, the rights, fundamental rights, that protection, right? I think we can look at it from two perspectives. One is that through these acts, some of the rights which have been won over or given by the Supreme Court in so many different rulings, now they might get negated because of it. One example of that I can give you is adultery. Adultery was considered as unconstitutional. The Supreme Court said we cannot have this, right? If you look at the BNS, they have taken it away, but instead of that, they have put in another provision which is much more wider, which says that even if you induce a married woman and ask her to run away, not even sexual intercourse now. Adultery was only about sexual intercourse, but here, if a man is taking a married woman away from her house, right, or away from her husband, then the man will be held liable. So expanded version of adultery, not even required to show a sexual intercourse, merely inducement. Inducement is again very vague. Inducement means what? If for example a married woman is there and she is suffering from domestic violence, and I say, okay, I'll give you a better life. In a way, that also amounts to inducement, right? And why only male is getting targeted in that, right? Because running away should be not such an offense when you look at the criminalization process. So no discussion happened with that also, right? So you are going back onto the constitutional mandate by the Supreme Court, because it's a order by Supreme Court, judgment by Supreme Court, which has to be followed. But now that won't be followed. So overall, I think it is a missed opportunity.
But Professor, I think that of course crimes are being categorized into crime against body and crime against property. Now, by giving precedence to any offences against the women, at least in the numbering pattern in the sections, right? Don't you think that they have made it more structured? Because when you compare BNS with the IPC, the crimes against the state were given precedence over the crimes against the body, especially crimes against women. But now the BNS has kind of given more precedence to the crimes or offences against women.
When you look at the scheme of it, it's only used to organize crimes in a better way for our reference purpose. But I wouldn't say that we can say it is giving more precedence to crime against women or some other people, because that way, if you look at the definition, they'll get the most preference. Alright, so it's not like that. Obviously, the state has to give equal care to everyone involved. Having this separate chapter in itself, which is crimes against women and children, right? That shows that yes, they are serious about protecting them. But the scheme in itself does not show that.
I agree.
And
I agree.
one more before we go ahead to the next speaker. So those who are convicted of more than one offence, they cannot take the recourse of statutory bail. So what is that about, sir? I mean, are they doing away? They're removing the provision of statutory bail because if you are, accused of two offences.
Right. See, statutory bail. Of course, if statutory bail is not there, offences where bail has to be granted. They are bailable offences. So court cannot deny that bail. Now, according to the new changes, if you have done the offence twice or repeat offender, right? So in such cases, you may be denied bail. That is, you cannot claim that bail as a matter of right. But it does not mean that that person will not get bail at all. Because even if an offence is not bailable, the court can still grant you bail based on its discretion. Again, obviously, there's a test and all those things are applied there, that the person will not run away or will not tamper with the evidence, etc. Right? But I don't think that they are doing away with bail in such
But to my
offences.
understanding, I think as per the CRPC, the accused should have served the half trial before he can file the bail statutory bail provision.
So that's what I'm saying. Statutory bail does not or cannot go against the discretion which is given to the court.
Okay.
Because this is the rule by the Supreme Court also. Bail is the rule, jail is the exception. Even in statutory bail, those offences which are bailable offences, court cannot deny anyhow. But in other non-bailable offences, court can deny based on certain circumstances. But I think in a way it is making it more difficult to get bail even in bailable offences.
Yes,
that's probably the change.
And I was also, intrigued by the provision of, the forensic part, because for now, any offence which is attracting more than 7 years of imprisonment, it has to be compulsorily been sent to the forensic experts. So, do we have the sufficient forensic infrastructure before making such kind of?
I think in the changes, when they are bringing for these changes, they themselves said that to implement this section properly, we need at least 5 years to develop the capacity. Of course, we have forensic labs, etc. But proper training is not there. There are so many cases. I can tell you one very popular case where because of lack of this forensic understanding during investigation, they lost the case, that Arushi Talwar's case, Nupur Talwar's versus state of UP, right, where they could not find the proper evidences, even though it was there. The fingerprints were there, the blood samples were there, but they misplaced it. They did not know how to take the samples itself. right? So that even it's a very good change. I think that is the one of the most wonderful aspect of the recent changes which are made in BNS is that they have introduced forensics investigation as well as videography. Although I agree that there are some problems to it, but it will help more in
Right,
investigation.
Professor. In fact, I was wondering. I had a word with the police officer. He said that if a crime is committed in Rajasthan, the nearest lab that we have is in Ahmedabad,
Yes.
and for that it's a 6 month waiting time.
Yes.
I mean,
That's exactly what I meant. That there is no capacity program or sorry building program that is there. We need more labs. There are some, I think hardly 15 to 16 labs if I'm not
in
wrong.
India.
Not
Yes.
even- I think
Yes.
it should be less than
Less than
also.
that, less than that, and the
Yes.
pendency of cases, six
Yes.
months waiting is there.
Yes,
I was also
and
intrigued by Sir cash against vote being declared as a crime.
Uh,
If you can share some insights over it.
I mean that is already an offense under People's Representation
Okay, alright.
Act. So it's not again a new offense.
Ah.
In a way, if you look at the changes, there are so many offenses which are already an offense in special acts. So when it comes to implementation, I don't think there is going to be any change as such. For example, another section is Terrorist Act. In Terrorist Act also we have already UAPA is there.
Pota, erstwhile Pota.
हाँ,
Tata
erstwhile.
is still there.
But UAPA is the one right now. NSA is there. So
Yeah.
already we have this. So material change won't be there in this cash for vote also. People's Representation Act already makes it a criminal
Yeah.
offense.
Maybe we explicitly mentioned it. Anyways, yeah.
with this analysis, with this discussion, we eventually come to this analysis that BNS is, in fact, the new criminal code is something which is very new. The implementation is still not there to a wider extent, and the results are still a question. If the implementation is not properly done yet, the results are very vague to discuss upon, and it was just our insights, our opinions about it. The time shall speak for itself, and changes are good, but whether they are too good to change an entire law and bring a new one, or a few changes would have been good enough, that would be something to discuss upon, maybe sometime else. So thank you so much. Thank you, Professor Karan. Thank you, Prithvi sir. Thank you, Prajakta, for joining us today. Thank you so much.